So we have the legislation, and actually right now it's being investigated. The Director of Military Prosecutions, Brigadier Lynn McDade, has been investigating a particular incident involving Australian Defence Force personnel in Afghanistan. Some of you will know about that from the press, and apparently her recommendations have gone to the Chief of the Defence Force, and we're waiting to hear what his reaction's going to be. But the point is, we have the legislation in place, and as long as we're prepared to take a bona fide approach to utilising it where that is required, we have nothing to be afraid of, and neither do many other countries around the world. But there are plenty of people also who either are or should be afraid of the International Criminal Court because they are responsible for perpetrating crimes against humanity, acts of genocide or war crimes. There are, unfortunately, I would say, also examples of people being afraid of the International Criminal Court for the wrong reasons. I might start with those before we get into people who are afraid for actually the right reasons. I learnt last week in The Hague, to my dismay, that there are some very serious allegations in relation to one of the current trials happening from the conflict in the Congo, that some of the individual witnesses brought by the prosecution, and the allegations actually are also made now against the defence team, to argue or to share their testimony about the recruitment and deployment of child soldiers in that conflict, have actually been intimidated by those individuals acting either for the prosecution or for the defence team who have interviewed them, who've tried to identify the witnesses that can come forward to argue, in the case of the prosecution, for this policy of recruitment and deployment of child soldiers, or in the defence team to argue that in fact it didn't happen, or these children weren't under 15 years of age or whatever else. So there is evidence of a number of people in the Congo afraid of the International Criminal Court because of the threats that have been made against them if they actually testify to the court, if they bring the evidence that they have been asked to bring, or to try and give stories that counter the evidence that's already been brought. That's very unfortunate in my view. I also want to recount a different example of fear about the International Criminal Court, which I think is, not quite rightly placed. I had a great experience, well, it was interesting, cultural experience, a couple of years ago, teaching in a few days in Kuala Lumpur to a group of Malaysian government prosecutors. And I was teaching them about international criminal law, and particularly about the International Criminal Court, and I split them into small groups with a task, and I asked them to report back to me, after they'd consulted with each other, on the current state of Malaysian criminal law and the extent to which the crimes in the Rome Statute were already covered in Malaysian domestic criminal law, so that if there was ever an allegation against a Malaysian national in relation to one of these crimes, whether that person could be prosecuted domestically in Malaysia. I sent them off, as you do, into small groups for 15 minutes. Call them back in. First group, who's the spokesperson? What's the answer? Our advice would be that we shouldn't ratify the Rome Statute. No, you got it wrong. That's not the question. Let's just assume that we are going to ratify. Malaysia is going to ratify the Rome Statute. What's the current state of Malaysian law? No, I'm sorry. No, we shouldn't ratify the Rome Statute. What do? You tell them they're an idiot? Don't you understand the question? I chose not to say that. And after trying to push this person, I thought, well, okay, I'm not going to embarrass him anymore. Okay, let's go to group two. Now, what's your answer to the question? Our advice would be you shouldn't ratify the Rome Statute. No, you've misunderstood a little bit slow is Timbo sometimes, You've misunderstood the question. Do you want me to say it again for you? No. Our advice would be we shouldn't ratify the Rome Statute. All right, so at that point I thought, well, there could be a bit of a cultural gap here, so just, you're there in Malaysia, Tim, you just got to slow down a little bit and try a different tack. What's the problem with the Rome Statute? Well, Article 27 says there is no immunity, even for a head of state. And if we ratify the Rome Statute, the king would not be immune. No, that's right, he wouldn't be. But he wouldn't have to worry about his lack of immunity before the International Criminal Court unless he perpetrated a crime against humanity, a war crime or an act of genocide, says me. Thinking, this is going to satisfy him, no problem. As long as the king doesn't do that stuff, he's fine. Oh, no, you don't understand. No, the king is immune. Can't be prosecuted. Can't be prosecuted in Malaysia and can't be prosecuted in The Hague. And because the statute allows for that possibility, forget about how likely it might be, Malaysia shouldn't become a state party. Well, at that point I thought, well, you just got to learn from this. And that exercise didn't work here. So move on. But I think that that's a wrong reason to be afraid of the ICC statute, even though it's a real one. And it's not only Malaysia, I don't believe, that feels this way about the particular provision in the statute that does not respect the person's office or position in a particular society. That's very different at the domestic level, but not at the International Criminal Court level. What about being afraid for some serious reasons? Yeah, there are plenty of those. Despite President al-Bashir of Sudan's bluster about how I don't recognise the International Criminal Court doesn't exist for me, I don't care about that. We're not a state party. We exercised our sovereign discretion not to become a state party to this statute, and I don't care what the International Criminal Court says. But he does care. He was told, apparently, allegedly, by the South African government that if he came to South Africa to attend the African Heads of State Summit, he would be arrested. South Africa is a state party to the Rome Statute, and the South Africans didn't want the embarrassment of taking the President of Sudan into custody, so they told him, if you come, that's what's going to happen. So the point about President al-Bashir, despite his bluster, is that the number of states that he can now visit confidently, comfortably, is significantly limited as a consequence of the ICC's issuance of an arrest warrant against him. And he is right to be afraid, at least on the face of the evidence, because it suggests that the Sudanese government has not only been complicit in the acts of the Janjaweed in Darfur, but has actually been supplying military equipment, making it possible for the Janjaweed to do their rape and pillage and destruction of the villages of the Fur and the Margalit and the Zagawi peoples of the Darfur region. In addition to that particular example, there are a number of others as well. In the case of Israel and its incursion into Gaza, and even more recently in relation to the way its forces stopped the flotilla trying to enter Gaza, the Israeli government has come to understand that the issue of dual nationality of some of its citizens could be a huge problem for it. Remember that apart from the triggering mechanisms, the first admissibility criteria, if the Security Council doesn't refer a situation to the court, if a case comes by way of state party referral or the prosecutor acting on their own initiative, the ICC must have the consent of either the state of nationality or the territorial state. There are issues about the legal status of Gaza and the occupied Palestinian territories. Israel is not a state party to the statute, but some senior Israeli military personnel are dual nationals. And the second state of nationality is sometimes a state party to the Rome Statute. In those circumstances, the prosecutor is looking at the question. This is on public record. I'm not disclosing confidential information. I'm trying to, in my own mind, without telling you, keep that demarcation clear. The prosecutor is looking at that possibility, where the second state is a state party to the statute, so the ICC can claim that that state is already deemed to have given its consent as a consequence of its participation in the Rome Statute. So Israel is afraid because it doesn't want its personnel tried by the ICC. Goldstone report has called for the situation in Gaza to be referred to the ICC if after 6 months Israel and Hamas have not adequately investigated and tried those responsible for Rome Statute crimes. That 6 months has elapsed, and the international community is clearly giving both Israel and Hamas more time to undertake their own investigations and to exercise their own national jurisdictions. And in terms of consistency with the complementarity formula, the ICC would have to be satisfied that either Israel or Hamas were unwilling or genuinely unable to deal with the particular cases before they could try them themselves. Another example of those states who are rightly afraid of the ICC, in my view, are those states that are engaged in activities which allegedly constitute Rome Statute crimes. Even though they are not states parties to the statute, they are afraid of the prosecutor's proprio motu, his acting on his own initiative powers. The United States has articulated its concern about that authority that the prosecutor has. I had a very interesting conversation with one of my master's students who, when he's not here studying with us, works for the Foreign Ministry in Jakarta, the Indonesian Foreign Ministry in Jakarta, not the Australian Foreign Ministry in Jakarta. And he said to me, we are afraid of the proprio motu powers of the prosecutor, because that's sort of taking it out of our control. The prosecutor can exercise his own initiative to go to a pre-trial chamber and say there's a case to answer here, and the prosecutor is then given the authority of 2 out of 3 judges, then we've lost control of the process. And the fact that we didn't sign up to the statute, we chose to stay outside of it thinking that we would be somehow or other immune from prosecution before the ICC, has suddenly proved to be wrong. That is Sudan's experience in the case of the issuance of the arrest warrant against Omar al-Bashir. If the UN Security Council is prepared to refer a situation to the court, then the question of the consent of either the territorial state or the state of nationality is no longer an issue. Complementarity formula still is, and there are a number of states that are very concerned about that. The US delegation in Rome in 1998 said that if the consent of the state of nationality was always required, so if it was the only state that could give its consent, or if the requirement in the statute was that both the territorial state and the state of nationality had to give their consent, that'd be fine. Because there's no way the UN Security Council is going to refer a situation involving a vested interest on the part of any of the 5 permanent members of the Security Council, is it? I mean, the US can veto that, the UK, China, Russia, France. There will be no referrals by the UN Security Council of Chechnya or of Guantanamo Bay or of any other situation where one of the 5 permanent members of the Security Council has a vested national interest. This is one of the problems with limitations to the court's jurisdiction. So if you've got the situation where the state of nationality must consent and the US knows that the Security Council isn't going to refer a situation, then all of a sudden a lot of US concerns evaporate. But because the territorial state alone can give its consent and the prosecutor can act on his or her own initiative, that puts it out of our control. That's the point I think that Prince Said is making. The Rome Statute represents a challenge to unbridled sovereign excess. Okay, let me just give you a couple of other examples of states that should be afraid if they're not at the moment. One of those, in my view, is Sri Lanka. There are some incredibly serious allegations about the conduct of the last few months of the Sri Lankan civil war. The International Crisis Group in Brussels just a month ago issued a report about this particular phase of the conflict against the Tamil Tigers. And they allege, that organisation alleges in that report, that in those last few months, Sri Lankan government authorities went so far as to declare safe havens in the Jaffna Peninsula, and after Tamil civilians came in to those safe havens, then government forces opened up with automatic weapons and killed thousands of them. And if those allegations are true, and I don't know because I have no first-hand experience, but the International Crisis Group is not known to make outlandish claims. If those allegations are true, then Sri Lankan government authorities should be afraid of the International Criminal Court. Sri Lanka is not a state party to the Rome Statute and won't become one. The UN Security Council apparently has no appetite to look seriously at the Sri Lankan situation. But again, as with Israel, there are suggestions that there might be some individuals very senior in Sri Lankan government circles with dual nationality. And some of those states, second national states, may already be states parties to the Rome Statute. And if they're not, they might be convinced that this situation is serious enough to warrant giving ad hoc consent. I think that there might be some governments around the world who, at the moment, aren't concerned about the ICC, aren't afraid of what it might mean for them, but who perhaps ought to be. Another example of those who perhaps should be afraid and might not be relates to Hamas and the Palestinian National Authority. Very interesting situation because the Palestinian National Authority went by delegation, senior delegation, to the ICC in The Hague and lodged a declaration under the statute, under Article 12 of the Rome Statute, accepting the jurisdiction of the ICC ad hoc for the Gaza incursion by Israeli Defence Forces. Prosecutor now has a huge dilemma trying to determine whether or not a non-state, like the Palestinian National Authority, can actually lodge an effective declaration under Article 12 accepting the jurisdiction of the court. That provision talks about a state, not party to the statute, accepting the jurisdiction of the court. And the possibility in relation to Hamas and the Palestinian National Authority, we don't know what's going to happen. The prosecutor hasn't made his decision. He's called for submissions. He's publicly listed the submissions that he's received, at least by those people who are happy for them to be made public. And his office has provided a summary of the arguments for and against on this question of whether or not that declaration can be valid under the statute. But there is a possibility, ironically, in all of this, that even if it is declared to be valid, it might only be valid in respect of Palestinian nationals. And Hamas and the Palestinian National Authority may actually, by making the declaration, then render only Palestinian nationals subject to the jurisdiction of the ICC, which is clearly not what they intend to do. So they need to think through the strategy, if that's the way that it's interpreted, because they might end up having to deal very seriously with their own investigations and prosecutions, or else face the prospect of Palestinians being tried by the ICC for their rocket attacks on Israeli settlements just beyond the border of Gaza with Israel. There are a couple of issues I'd like to finish up with and then ask for questions if any of you have them. One of those is that the International Criminal Court really relies on the cooperation of both the international community collectively and states individually, or maybe collectively in their own regional groupings. The International Criminal Court has no police functions. It can't go into Sudan and arrest Omar al-Bashir. It can't enforce any of its indictments and arrest warrants. It relies on the cooperation of the international community for it to be able to do its work. And I think that means that those of us who are fortunate enough to live in democratic societies have to demand more of our governments to work with the court to help make it as effective as it can possibly be. We know that governments respond to electoral pressure. That's the way that it happens in our system. Maybe it's unfortunate in some ways. Every now and then they'll take policy decision that's very unpopular, but then maybe backtrack on it when it really costs them in terms of the polls or at the on election day. I think we need to ask more of our governments to work with the ICC to help make it as effective as it can be. And just to finish up, the biggest single challenge to the International Criminal Court as an institution and to the much broader international criminal justice experiment is the lack of systematic and comprehensive application of the law. There's no way the ICC achieves that and won't in its current format, and there is no way that even with supplementary proaction by states that we have arrived or are anywhere near close to arriving at that particular point. And that ought to be, must be, a source of discomfort. For me, it's not an argument against the merits of the International Criminal Court, but it is something that we have to be constantly vigilant about and remind ourselves about. Because until that happens, until we have comprehensive and systematic application of the law, then we can't kid ourselves about what we've really achieved by establishing the International Criminal Court. Thanks very much for your attention.